Hi, my name is Anton and I'm head of growth at LexStart. If you haven't seen the previous video, I highly recommend you do before going any further. Because in this video, we are going to talk about the details of a shareholders agreement. So, why would you need a shareholders agreement? A good shareholders agreement will anticipate a number of situations that may arise in the life of your business, thereby protecting the interests of your company in the case of a dispute. The agreement will typically regulate the transfer of shares, since this is frequently a source of conflict between shareholders. For example, you should prepare for a departure of a shareholder. In the absence of a shareholders agreement, the applicable laws will intervene to settle the dispute. This means that shareholders will have to refer to the law, to an arbitrator, or even to the courts to resolve their issues. However, these solutions will not always be catered to the specific needs of your business. With a shareholders agreement, you can establish practical solutions to conflicts that may arise, which will be better suited to your business. It is important to establish how the value of shares of your company will be determined. This will make it easier for the shareholders to transfer their shares. A fair market value clause allows you to determine in advance what method will be used to evaluate the shares of a shareholder seeking to sell their shares. As a general rule, clauses that establish how the shares of a company can be transferred, be it sale, purchase, or redemption of shares, are very useful, in particular when the third parties want to become shareholders of your company. Certain clauses allow the shareholders to control the sale of shares and protect the founders of the company as the principal shareholders of the business. For instance, the right to first refusal forces a shareholder looking to sell their shares to first offer those shares to the other shareholders, proportionally to the shares they hold in the company. If they decline the offer, the selling shareholder will then be entitled to find a third-party buyer. Similarly, the right to first offer clause forces any shareholder having received an offer to purchase their shares from the third party to first offer their shares to the other shareholders for the same price and conditions as the offer from the third party. Moreover, a preemptive right clause gives shareholders priority to purchase new shares that may be issued by the corporation, proportionally to the shares they already hold. This allows them to maintain the proportion of shares in the company. There are two categories of shareholder resolutions: ordinary and special. Ordinary resolutions are resolutions that do not entail major changes to your business. They are adopted by a simple majority or the shareholders with voting rights. The nomination of an auditor, the election of the directors, or approving the decisions of the board of directors are all examples of ordinary resolutions. Special resolutions are resolutions that deal with major changes to your company. They require 2/3 majority in order to be passed. For example, any modifications to the statuses of the company or the addition or subtractions of shareholder are considered special resolutions. In a shareholders agreement, you can determine that certain types of resolutions should require a special majority or even the unanimous consent of the shareholders. As a general rule, a shareholder's right to vote is proportional to the number of shares they hold in the company. However, the founders of the company can decide the status of the company will contain several classes of shares with varying rights, such as multiple votes, the right to elect a director, a preferential right to dividends. In example, the shareholder will have priority over shareholders with the other classes of shares to receive a dividend. A shareholders agreement will regulate the departure of a shareholder, be it regularly or forced. The retirement from business clause lists events that will lead to the forced departure of a shareholder, who will then have to sell their shares to the other shareholders. For example, if a shareholder fails to fulfill their duties to the corporation for a certain period of time, they can be forced to leave the company. A shareholders' agreement can provide for what happens in case a shareholder dies. The death clause can force the heirs of the deceased shareholder to sell the shares they receive back to the shareholders. A shareholders' agreement can contain clauses that impose certain responsibilities on shareholders and ensures their loyalty to the company. For example, a non-compete clause that prevents shareholders and ex-shareholders from engaging in business that is direct competition with the company. A non-solicitation clause prevents shareholders and ex-shareholders from soliciting the contacts of the business for their own personal venture. A confidentiality clause prevents shareholders and ex-shareholders from divulging any information they have received through their work for the company that is deemed to be confidential. Be careful. This clause must be drafted reasonably. In other words, it must be limited in scope and time and have precise object. In other case, it might be invalidated by a judge. Now, you should have a better understanding of the importance of a shareholders' agreement and why you need it. In the next video, we will show you the Lex Start process and how we can help you. Thank you, and see you soon.